and without leave of court. A claimant must count his relief to avoid the relief one, which is the principal claim, and claim that such termination was wrongful and illegal. Then the defense counsel submitted that by failing to tender the said letter of termination, which is the bedrock of his claim, the jurisdiction of the court was ousted. When the cause of action arose was unknown, and it was a deliberate ploy to hide the reason for the termination, which was clearly stated in the termination letter of 15th of May 2022. The jurisdiction of NICN is primarily derived from the 1999 Constitution section 254C, and it is further elaborated by the NICA Act of 206. It has exclusive jurisdiction over civil causes and matters relating to or connected with labor, employment, and industrial relations. Its core jurisdiction encompasses all disputes arising from employee-employer relationship, conditions of service, wages, salaries, allowances, and other, or between trade unions themselves. These cases, Sky Bank versus Iwu, and in Olorunloba Ojo versus Dopamu, the Supreme Court emphasized that the NICN is the proper forum for all employment-related disputes, which includes claims for damages, where the negligence is intrinsically connected to the employment relationship, such as a breach of the employer's statutory or contractual duty of care owed to the employee. The jurisdiction conferred by Section 254C is broad enough to encompass such ancillary claims arising within the employment context. A look at paragraph 1 of the statement of fact, the claimant averts he was employed in 2018 as a lamination machine operator, and in paragraph 3 averts that the relationship was a master-servant relationship. Paragraph 7 to 13 are claims from the alleged incident and its treatment plan. The law is straight that fundamentally an employment relationship is a contract agreement where the employer agrees to render service to the employer in exchange for remuneration. The Nigerian law recognizes various types of employment relationship: master-servant relationship, statutory employment, it may be permanent, fixed, temporal, or casual. See Ujam versus IMT and Okemi versus Pyramid Company Limited. Citations are all provided. Also, the law recognizes that it can be written or oral. The law in establishing relationship will rely on oral job duties to determine the relationship. The court noted that defendant's admission that the claimant was given a note, in other words, a referral to Ribi Hospital, and a subsequent referral to Metro I for further treatment. This could only have occurred within the context of an existing employment relationship between the parties. This fact clearly demonstrates that such a relationship did indeed exist. Therefore, the argument advanced by the defense counsel that the claimant's failure to tender his employment letter is fatal to this case and deprive this court of jurisdiction is misconceived and misleading. Having established that there is an employment relationship between the parties, this court is properly vested with the jurisdiction to adjudicate, or CN has jurisdiction over matters relating to negligence, provided the negligence is directly linked to the employment relationship, and the jurisdiction to entertain this matter. This issue is resolved in the affirmative, I so find. The second argument of the defendant is that reliefs 3 to 6 in the statement of fact cannot be granted as they relate to claims in tort arising from negligence and damages. In paragraph 4.4, he submitted that claims for injury from employment must be specifically pleaded either under the Workman Compensation or Termination of Employment Convention 19. It cannot adjudicate on any claim in tort. Citations are all provided. In a claim bordering on tort of defamation, even when connected to the employment and labor matters. Learned Defense Counsel submitted that the claimant should have claimed for either unlawful termination, damages flowing from failure to pay salary in lieu, failure to pay pension, etc., as the damages claimed in 3 to 6 relate to tort of negligence outside the has jurisdiction over torts committed in the workplace. Honorable Justice B.B. Kani, PhD, OFR, President of the NICN and member of ILO Committee of Experts on the application of convention and recommendation, which was delivered at the NECA National Labour Adjudication Forum and the future, where his lordship espoused thus, and I quote, the question whether this court has jurisdiction over defamation in particular and tort in general has been a vexed one. The earlier decisions of this court held that this court does not have jurisdiction over defamation, even if it arises from the workplace. Naturally, the Court of Appeal has been approached to make a determination in this regard. Unfortunately, the decisions of the Court of Appeal has oscillated in that regard. Akpan versus Unica citation provided and Bisong versus Unica citation also provided. For instance, respectively affirmed the decision of Baseki Osage J of the NICN that the NICN does not have jurisdiction over the tort of defamation. And in Medical and Health Workers Union of Nigeria versus Dr. CA/B/4041/2013, the judgment of which was delivered on the 4th of May 2016, the Court of Appeal, the Benin Division, per his lordship Oniyan, Benin City, which held that jurisdiction over defamation lies with the State High Court, not the NICN. The thing to note here is that the Court of Appeal, in same case, same appeal number, the different panel of justices came to the very opposite conclusion, where the same Benin Division of the Court of Appeal held that the NICN has jurisdiction over defamation arising from the workplace, given the, and I quote, matters incidental thereto or connected therewith, end of quotation. Phrase used in section 254C sub 1 of the 1999 Constitution. Earlier decisions of the NICN, where it was held that the NICN does not have jurisdiction over defamation, were held by the Court of Appeal in Medical and Health Workers Union versus Dr. Alfred Ehiegiagba to have been wrongly decided. Because of this, the 2018 Court of Appeal decision and the ruling of an appellate court is to be preferred, this court had to hold in succeeding cases that it has jurisdiction over defamation. This was the case in two suits, Mr. Olu Fashion versus FBN Capital Limited, unrepeated suit number NICN/LE/87/2014. The judgment, which was delivered on the 18th of June 2019, and Lucia Balong versus Voluntary Service Overseas International. However, the Court of Appeal appears to have retracted, and so in EcoBank versus Idris, it held that the NICN does not have jurisdiction over defamation. So this is the current position. Now, back to the case at hand. Defendant Counsel's second argument is that reliefs 3 to 6 in the statement of fact cannot be granted as they relate to claims on torts arising from negligence and damages. Firstly, let me correct the submission of Defense Counsel. Compensation Scheme, ESC, governed by the Employee Compensation Act 2010 and not the Workmen Compensation Act as mentioned in his final written address. The ECA repealed the previous is misconceived and highly misleading, and it is discountenance. Secondly, Defense Counsel argued that the claims for injury from employment must be specifically pleaded in ILO 8. This is the convention that sets out minimum standard for job security, requiring a valid reason for termination and providing remedies for wrongful dismissal, such as reinstatement or compensation. The part Defense Counsel is towing should seek in court. It is tried that a defendant cannot dictate how a claimant should present their case. The fundamental principle of civil litigation in Nigeria, as in many common law jurisdictions, is that the claimant is a master of their own case. This means the claimant has the sole responsibility and prerogative to formulate their claims, define the issues they wish the court to determine, and present the evidence they deem necessary to prove their case. Since Jibril versus AG Edo State, to formulate their claims or relief being sought in an action brought by them. Similarly, in First Bank Nigeria PLC versus Imaswen citation provided, the Court of Appeal emphasized the duty of a plaintiff to formulate issues for determination in a case. This judicial pronouncement underscores that the claimant initiates the action and sets the parameters of their case. including the facts they rely on, the legal arguments they advance, and the remedies they seek. The role of the defendant is primarily reactive to the claimant's case by filing a statement of defense which addresses the allegations made by the claimant, raises specific defense, compel the claimant to plead certain facts, call particular witness, or adopt a specific legal strategy. This structured approach ensures that each party has the right to conduct their respective cases independently. Both sides have the autonomy to manage their respective cases without one dictating the other's presentation. In essence, why defendant defense will naturally influence the overall trajectory of a case. To detect the manner in which the claimant presents their initial case, the claimant bears the burden of proof and is solely responsible for establishing their claims before the court. The defense counsel argument on how the claimant should have couched his claims is hereby discountenanced. I go to the court's decision. In Nigeria, compensation for workplace injuries is governed by both the Tort Law and the Employee Compensation Act 2010. Under Section 12 of the ECA, a victim must choose to either get compensation under the ECA or under the Tort Law, not both. And the court is left to accordingly determine whether the claimant's case was in negligence and if it is, what conduct of the defendant constituted it. It shall now address the relief claim seriatim. Relief 1 is for a declaration that on grounds that he refused to receive a query issued to him is wrongful, illegal, same is against the principle of equity and natural justice and fair hearing. The burden of proof for wrongful termination of employment squarely rests on the employee who alleges that his employment was wrongfully terminated. See cases like UTC versus Peters, Kato versus CBN, Bolu versus FCE Ogudu. Citations are up. The employee must establish some key elements. The employee must present the contract of employment, written or oral, and clearly prove its specific terms, the conditions and procedures for termination. See ABU Zaria and Idenyi and First Bank versus Momo. Failure to plead and prove these essential elements result in a claim for wrongful termination failing. The employee cannot simply assert wrongful termination. He must lay the factual and the legal foundation for such an assertion. Furthermore, a bias or a failure to afford the claimant a fair opportunity to be heard, which must be proven, not merely asserted. In the instant case, the claimant in paragraph 1 of his statement of facts and paragraph 2 of his written statement on oath averred that he was issued a contract of employment dated 9th of July 2021. However, the said contract of employment was never tendered before this court. The condition of service or handbook, which ordinarily would have contained the terms and conditions of the employment, is conspicuously absent from the exhibit standard. The relief sought is for a declaration that the purported termination on grounds that he refused to receive a query issued to him is wrongful, illegal, same is against the principle of equity, natural justice, and fair hearing. The burden of proof in labor matters lie on the claimant to establish the case on the balance of probabilities. While the claimant presented sufficient evidence, including testimony, to establish the fact of termination, the failure to formally tender the letter of termination presents a procedural gap. It is worthwhile to note that the letters of claimant of his own volition failed to tender in BON Limited versus Babatunde citation provided, the Court of Appeal held that where a document is pleaded but not tendered in evidence, the paragraph of the pleading relating to the document is deemed to have been abandoned. The failure of a party to produce any document that is pleaded precludes the court from relying on it. See Kara versus Washa and Oyediran versus Alebiosu and Bello versus Otolorin. Citations are all provided. This omission primarily impacts the specific relief. So the implication of what the claimant has done is to not do. See Oyiloye versus Esikin. Citation provided. Now, in this case, the effect of claimant's failure to tender his data of termination improve of wrongful termination of employment, as well as fail to provide ample evidence to establish the terms of the contract of employment between himself and the defendant, is fatal to this case. To succeed in a wrongful termination claim, the employee must clearly present the employment contract, prove that the employer or statutory rules governing the relationship. I therefore find that the claimant has failed to adduce sufficient credible evidence to satisfy the requisite standard of proof on the balance of probabilities. Consequently, the claimant has failed to prove that his termination was wrongful, illegal, or contrary to the principle of natural justice and fair hearing. The court has nothing to establish how termination of Mrs. Uma. In view of this, issue number 1 is resolved against the claimant. Relief 1 fails, I so hold.
Let's go, please.
Relief 2 is for an order that the defendant calculates and pays forthwith the leave allowance they claim the 4 years which he was employed by the defendant. Leave allowance in the context of Nigerian labor law refers to the remuneration an employee is entitled to receive during their period of annual leave. It is a fundamental aspect of employment benefit designed to ensure that workers can take a break from their duties without suffering financial loss. The concept is primarily governed by the Labour Act, which generally provides for annual leave for all workers. It is a statutory right ensuring paid time off of payment, flexibility in usage, and compensation in lieu, all designed to protect the workers' welfare and right to rest. It is documented in 2 main parts of the employment relationship. The employment less than what the law says. Secondly, annual leave is legally provided for in Section 18 of the Labour Act. The claimant is seeking for an order that the defendant calculates and pays the leave allowance for each of the years within the 4 years which he was employed by the defendant. As earlier decided in this judgment, the claimant neither tendered his employment letter nor the conditions of service. He failed to specify the amount he is entitled to. In fact, the leave and the allowance sought is unknown to the court. This court cannot give an order in futility. In the circumstance, relief number 2 sought against the defendant cannot be granted and it fails. The permanent injury sustained by the claimant was during his course of employment by the defendant. Hence, the claimant is entitled to compensation for permanent disability. This relief has 2 arms. The first is a declaration that the permanent injury was sustained during the course of employment. This court had earlier determined that various types of employment relationships exist, which include master-servant relationship. It may be permanent, fixed, temporal, or casual, and the law recognizes that it can be written or oral. It is tried that the court, in establishing such relationship, will rely on oral evidence, conduct of parties, job duties, and responsibilities to determine the relationship. In the instant case, this court is convinced that by the conduct of parties, communication between their counsel, and process filed, although the claimant failed to tender his employment letter, it was not fatal to the fact that there was indeed an employment relationship between the parties. I so find. The claimant alleged in paragraph 6 and 9 of his statement of fact that the process of operating the machine involved the use of strong chemicals that have 22 within the defendant's premises and workplace. He immediately used water as first aid, and when he could not bear the discomfort, he reported the matter to the defendant 10 days later. He was immediately referred to the defendant hospital, Ruby Hospital, and later to Metro Eye Clinic, where he was attended to by the optometrist. The question before the court, therefore, is whether the claimant was injured in the course of his employment. The defendant's witness, DW1, affirmed the veracity of where the accident happened during cross-examination. He was asked, will you agree that the eye accident of the claimant occurred while the claimant was working for your company? Answer, yes. The next question. And while he was working with company equipment, chemical, and machine, he answered yes. The above testimony corroborates the fact that this injury was sustained in the course of the employment, in the course of the claimant's employment with the defendant. It is tried that facts admitted require no further evidential proof. See NAS Limited versus UBA, Ambajudin versus Irum Kwanimo, Obimi Army, Brick and Stone Nigeria Limited versus ACB, and Olagunyi versus. This court is mindful of the decision in Akpan versus Union Bank of Nigeria, where the court held that the general rule of pleading is that what is admitted ceases to be in controversy between the parties, and at the trial need not be proved by any party. However, one of the exceptions to the general rule is that in action for declaration, the facts must be proved by evidence, even if they have been admitted. To prove the accident took place on the premises and upon report of the incident, he was referred Ruby Hospital and later Metro Eye Clinic. Claimant tendered Exhibit C4, which is the handwritten note for referral to Metro Eye Clinics. Exhibit C5 was also tendered, which is a handwritten prescription of eye drops dated 27th of June 2022. Exhibit C6, C7, and C13, which is the Metro Eye test report dated 27 May 2022, June 2022, and July 2023, respectively. By virtue of Section 254C sub 2 of the Constitution and Article 1 sub C of the Protocol of 202 to the Occupational Safety and Health Convention of Occupational Safety Health Convention 155, which was ratified by Nigeria on the 3rd of May 1994, occupational accident is defined as, and I quote, an occurrence arising out of or in the end of quotation. From the above facts and the reasoning, this court is convinced and accordingly hold for the first arm of the relief that the permanent injury sustained by the claimant was during his course of employment by the defendant. I so find and declare. For the second arm of relief 3, the concept of compensation itself has been judicially defined in Beneye versus Naok. The court citation provided where the court elucidated the meaning of compensation. Similarly, in NDPAC versus Antiv, citation provided, the court outlined what a party must prove to be entitled to compensation, typically requiring proof that the injury occurred in the course of employment and resulted in a disability. Also, the case of registered trustees of Winners Chapel versus Ikenna, citations provided, further highlights the circumstances under which a workman will be entitled to compensation under the relevant compensation legislation. This court therefore finds that since the injury was sustained in the course of his employment, he is entitled to compensation. I so declare. Relief 4 is for a declaration that the claimant owe a duty of care to the claimant. Relief 4 is for a declaration that the defendant owe a duty of care to the claimant by providing protective lens and other incidental essential accessories to the claimant, purposefully to protect his eyes from contact and interference with the chemicals used in production. But the defendant, having breached the said duty of care, is therefore liable in damages resulting into the permanent damage to the eyes of the claimant and for the tort of negligence. The averment of the claimant in paragraph 6 is that the process of operating the machine involves the use of strong chemicals that have fumes, which eventually has undiluted contact with the eye on a daily basis, whereas there was no training on the use of the protective gadget that could obstruct the fumes. In paragraph 7 and 12, he avers that the duty of care entails the provision of eye protective accessories while operating the lamination machine, regular on-the-job training, provision of hand gloves, being aware of the potential dangers the chemical poses to the eyes and the body. In his defense and response to paragraph 6, 7, and 12, the defendant stated in his statement of defense, paragraph 3 and 4, categorically that all staff, including the claimant, were provided with and trained in the use of the safe protective gadget and also ensured within its limit compliance with the safety procedure in prevention of accident. Furthermore, that the claimant always flouted the rules and protective procedures and did not comply with the safety procedure while in the employment of the defendant. Has to prove the trilogy of duty of care, breach of duty of care, and resultant damage. See Babatunde Ajala Right Park Company Limited, suit number NICN/LE/4 2019. This court had earlier found that the accident occurred in the course of his employment. The next consideration is whether the defendant owes the claimant the duty of care by ensuring that the claimant was secured against any form of injury in the course of carrying out his employment. On this second issue, the court noted that the claimant did not counter the fact that in the process of operating the machine, strong chemicals that have fumes were used, which eventually had undiluted contact with the eyes on a daily basis. The Court of Appeal in Ecto Nigeria Limited versus MA citation provided held that all workers are entitled to work in environments where risk to their health and safety are properly controlled. Employees and other people who might be affected by their businesses. The employer is also to provide safe systems of work to ensure work schedules and workloads do not create unreasonable risk, provide proper training and supervision, provide adequate PPE, and conduct risk assessment. From a community reading of the statement of defense, defendant did not controvert the averment of the claimant that the process of operating the machine involved the use of strong chemicals that have fumes, which eventually has undiluted contact with the eyes, undiluted contact with his eyes on a daily basis. The implication is that parties are in agreement as to the nature of the claimant's job and the level of exposure of the strong chemicals to the claimant's eye. In fact, in Exhibit GW1E, defendants in the NSITF form stated that the task performed at time of accident was he was cleaning machine when adhesive entered his eye. End of quotation. And the nature of the injury was, I quote, adhesive enter his eye. End of job. I so fine. Next, the defendant, in an attempt to discharge the burden of proof that had been shifted to him, stated in paragraph 3(5) that protective gadgets were provided, but the claimant flouted the rules and the protective procedure laid down by the defendant. The duty of an employer to ensure that the employees use protective gadgets is rooted in both common law principles of negligence and specific statutory provisions. This duty is not merely to provide the equipment, but to actively ensure its proper and consistent use by the workforce, thereby fostering a safe working environment. At common law, an employer owes a general duty of care to their employee to take reasonable steps to ensure their safety. This overarching principle has been consistently upheld by Nigerian courts. See Cabo versus Mohammed, citation provided. This duty extends to providing a safe place of work, safe fellow employees. The provisions and enforcing a safe system of work and a safe working environment. See also Iyere versus Bendel Feed and Flour Mill Limited, citation provided, which emphasize the general requirement of the law, where a service relationship exists between employer and employee, highlighting the employer's obligation to ensure the well-being of their staff. Beyond common law, specific statutory provisions, particularly the Factories Act 204, impose clear obligations on employers regarding provision of protective equipment. Section 47 mandates, and I quote, that where any factory workers are employed in any process involving suitable protective clothing and appliances, including, where necessary, suitable gloves, footwear, goggles, and head covering, shall be provided and maintained for the use of such workers. End of quotation. This section is crucial as it not only requires the provision of suitable protective gear but provided for the use of such workers. It goes beyond merely making the equipment available, trained on how to use and understand its importance, and are supervised to ensure compliance. The general duty of care, as articulated in Bello versus Dada, citation provided, discusses the duty owed by the employer to the employee, implies that the employer must not only make provisions but also ensure their effectiveness in practice. A failure to ensure the use of safety equipment, even if provided, could be seen as a breach of the employer's duty of care, potentially leading to liability for any resulting injuries. It is also important to note that the Factories Act Section 61, Sub 1 places a corresponding duty on the employer, does not absolve the employer of their primary duty to ensure compliance through supervision, training, and if possible, and if necessary, disciplinary action for non-usage. The employer must create a culture of safety where the use of protective gadgets is not optional but mandatory. Furthermore, Section 48, Sub 1 of the Factories Act specifically addresses eye protection, stating, and I quote, in the case of any of the processes specified in the fourth schedule of this act, suitable goggles or effective screens shall be provided to protect the eyes of the person employed in the process. End of quotation. This provision underscores the importance of hazard-specific protective measures. This section of the Factories Act demonstrates a legislative intent to ensure appropriate protective equipment. It need not be overemphasized that the duty of an employer to ensure the employee uses protective gadgets is a comprehensive obligation derived from both common law principles of reasonable care and specific statutory mandates. It requires the employer to provide suitable, well-maintained equipment, train employees in its use, supervise compliance, and enforce safety policies to prevent accidents and injuries in the workplace. This being it, to ensure the claimant not only was provided with the protective gadget, but used them. It is therefore the understanding of this court that the defendant failed to ensure that the claimant complied with prevent foreseeable injury. I so find. Claimant also raised the issue of training. See paragraph 6 of the statement of fact, line 3, and I quote, whereas there was no training provided on the use of protective gadget that could obstruct the fumes from the chemical to contact the eyes, end of quotation. The defendant put up the defense that the claimant was trained, but, and I quote, always flouted the rules and protective procedure laid down, end of quotation, and ensured with an exhibit DW1J, which is the Health, Safety, and Environment Policy. The defendant failed to show how sanctions of flouting safety procedures was enforced. Interestingly, query tweet had been issued to the claimant as far back as 2020, 2021, up until March 2022 were tendered before this court, but there was no evidence of a warning or a query issued to the claimant for failure to follow protective procedures, thereby exposing not only himself but other co-workers to dangers. This defense shall be regarded as condonation. See the case of Olareweju versus Afribank Nigeria Limited, where the court held that where there is delay in disciplinary action after defense and will lead to potential liability, could obstruct the fumes. In paragraph 6 statement of the statement of fact, the defendant stated in his statement of defense, paragraph 3, that all the staff, including the claimant, were provided with and trained on the use of the safe gadgets. An employer defending a legal action for workplace injury must prove that the worker was properly trained in the use of protective gadgets. This duty arises from both common law negligence of the Factories Act, which requires training and supervision of inexperienced workers, and Section 47, which mandates the provision of protective equipment. Provision of safety gadgets alone is insufficient. Employers must show that workers were instructed on their correct use. To prove adequate training or refresher training on procedure and equipment, an employer must present clear, verifiable document, dates, duration, topics covered, equipment discussed, trainer qualification, and participant signature, not leaving out the training materials, and also sign acknowledgement confirming the worker or workers received and understood the worker could correctly use the equipment, supervision records showing ongoing monitoring and corrective guidance. Judicial authorities such as Afrap Chemical Nigeria Limited versus Owodueni citation provided, where the court reinforced that employers must do more than show the worker accepted the job. They must prove they took reasonable steps to ensure safety through proper instruction. In essence, a defendant employer must produce a comprehensive body of evidence demonstrating that effective documented training on protective gadgets was provided, thereby fulfilling statutory and common law duties of care. Unfortunately, the defendant here failed to shift this burden of proof. I therefore find that the defendant owed the duty of care to the claimant by providing protective lens and other incidental essential accessories purposefully in production, and breached his duty of care to train on the use of the gadgets. This is the finding of the court. The defendant is therefore liable in damages resulting into the permanent damage of the eyes of the claimant and for the tort of negligence. Relief 4 succeeds, I so declare. Relief 5 is for an order that the defendant and in the sum of 20 million naira only, and same shall be payable forthwith to the claimant. by the defendant. The law is settled that general damage or injury flowing directly from the breach, it covers all losses which are not capable of exact quantification, including non-financial losses. A trial court has discretion when assessing the quantum of the damages to be awarded, relying on what would be an opinion and judgment of a reasonable man in the circumstance of the case. See Okoko versus Dakolo, citation provided. Also, above is the guiding principle for determination of quantum of general damages to be awarded in the context of a civil claim, awarded in the event a civil claim succeeds. The central question before this court is whether the claimant successfully demonstrated on the balance of probabilities that the permanent eye injury suffered was a direct and foreseeable consequence flowing from the defendant's proven negligence on the use of the safety gadgets and ensure compliance to safety procedure. The claimant maintains that the breach of the duty of care is the main cause of the damage he suffered, which Metro Eye Clinic diagnosed as glaucoma, which cannot be corrected. The law is settled that while a breach of duty establishes negligence, the claimant must further establish causation, that the breach was the effective cause of the specific injury claimed. Mere proof of breach and injury is insufficient. A direct causal link must be established. One loud argument of learned defense counsel is that the claimant is because his pleadings, oral testimony, and medical report contradict one another. According to the issue, and Exhibit C6 states that his petition, the incident, meaning around 18th to the 19th of June 2022. Therefore, the report was issued on the 27th. Therefore, the report was issued on the 27th of May 2022. Furthermore, Exhibit C6 does not confirm any permanent eye damage or any diagnosis of glaucoma linked to the chemical incident. Contrary to his own case, these contradictions undermine his claim and should be resolved in favor of the defendant. The effect of conflicting documents tendered in court is a critical aspect of litigation, as it directly impacts the court's ability to ascertain the true facts and arrive at a just decision. When documents presented by parties in a case contradict each other on material points, the court is faced with the task of resolving these inconsistencies to determine which evidence is more credible and probative. There is no gainsaying that once a document is properly tendered and admitted to consider, as established in cases like Odu versus Sadiq, citation is bound to consider these contents and give them the weight they deserve in the overall assessment of the evidence. Similarly, Jolima Nigeria Limited versus Liberty Bank PLC, citation provided, reinforces the principle that at this conflict, the court cannot simply accept all of them at face value. The primary duty of the court is to evaluate the evidence. The Court of Appeal in Mohammed versus Wada provided guidance on how to decide whether the contents of two documents are conflicting. A conflict arises when the document presents irreconcilable facts or propositions on the same material issue, making it impossible for both to be true simultaneously. The court must carefully scrutinize the documents to determine the nature and the extent of the conflict to uncover the truth when faced with conflicting accounts. It is tried law that conflicting documents in court do not automatically nullify each other. Instead, they trigger a judicial process of scrutiny and resolution. For documents, the court meticulously evaluates their probative value, their consistency with other evidence, the origin of the document, and its proven authenticity, the conditions under which the document was created, and whether there are any suspicious circumstances, the degree to which each document is relevant to the issue in dispute, and to determine which version of fact is more credible. The ultimate goal is to resolve the conflict, establish the true facts, and ensure that justice is based on the preponderance of credible evidence. The court took a incident on the 19th of April. The claimant was referred to Ruby Hospital and later referred to Metro Eye Clinic. On the 26th of May 2022, the claimant's lawyer wrote to Metro Eye Clinic and in paragraph 3 had requested, and I quote, for the written result of the eye test an expert report on the condition of the eye. End of quotation. In response, Metro Eye Clinic wrote a to whom it may concern letter dated 27th of May 2022. It is pertinent to note that Metro Eye Clinic also printed a detailed customized medical report which had claimants' biodata and 7 digital images of the eyes, and that report was dated 2022 June 24, tendered as Exhibit C7. The equation then is between these two documents, it aligns with other admitted evidence. But the sequence of events is now a mystery for the court to unravel. Defendant counsel did not avert his mind to the fact that, firstly, test using medical details and claimant's biodata to produce the medical result of the claimant with the date of eye examination embedded in the report. Exhibit C6, on the other hand, is a typed report by the optometrist, and the date was merely typed on Exhibit C6. Furthermore, during trial, claimant's counsel tendered another, and I quote, to whom it may concern letter from Metro Eyes. This time, it is dated the 28th of July, 2022. It was admitted and marked as Exhibit C13. That letter was formulated by the defendant but tendered by the claimant counsel through the defendant witness. The contents were same as Exhibit C6, but had additional information that the claimant had a follow-up visit on the 24th, 22, and was confirmed to be a case of, and I quote, glaucoma. And the report recommended, and I quote, consideration and support for him to help him comply with the medication. End of quotation. There is no doubt that Exhibit C13 is a latter document which states the health condition of the claimant. As for the probative value to attach to the date the report was issued, this court is convinced that the complications, which, and I quote, started 2 months after chemical entered his right eye while at work, end of quotation, in Exhibit C6 cannot refer or mean that the report dated 27 May was written or issued before the commencement of the symptoms as argued in paragraph 4.8 of the defendant's final written narrative. The correct date the eye test was conducted, which was the 24th of June 2022. After all, Exhibit C13 stated, and I quote, further confirmatory tests such as autoperimeter and OCT were carried out on the 24th of June 2024 and 28th of July 2020. Sorry, on the 24th of June 2022 and 28th of July 2022, respectively. End of quotation. In other words, the complaint presented his eyes, that is, April. To succeed in a negligence claim, a claim suffered that the breach was an effective cause of the specific injury claimed. See on or limited citation provided. The court evaluates causation through factual causation. That is the Beckford test, where the plaintiff must show that the injury would not have occurred but for the defendant's negligence. This establishes that the defendant's breach of duty was a necessary condition for the damage or harm. This was established in SBN Limited versus Company Nigeria Limited versus GTB PLC, citation provided. The Court of Appeal also affirmed in Young versus Idimi, and another citation also provided that the plaintiff bears the burden of. In the instant case, after the claimant reported that there was a splash of chemical in his side, he was referred to 2 hospitals. The complaints presented to the Metro Eye Clinic as shown in C6. Mucus discharge, sensation whenever patient bends down, difficulty opening eye fully. End of quotation. Consequently, patient was diagnosed of mild ptosis, hyperopia, mild bacterial and allergic conjunctivitis. Finally, adequate medication and anti-reflective lenses were prescribed for the patient. Patient will need follow-up visit and a consultant's review at our outlet in Abeokuta. End of quotation. The question is, would this complaint have occurred but for the defendant's negligence? This court is convinced from the reasoning advocated above that the injury would not have of care to provide the protective gadgets, train and ensure compliance with protective procedure. Secondly, even if factual causation is proven, would the damage be what a reasonable man would anticipate as a result of the associate citation provided underscores that by the breach, but also be of a type that is not remote. On the issue of glaucoma, in paragraph 13, claimant averred the statement of fact that the main cause of the damage suffered which was diagnosed as glaucoma, was due to the breach of the duty of care. The defendant, in his statement of defense, that, and I quote, the glaucoma affected by the claimant and was not due to the alleged splitting of the chemicals. The claimant has suffered this disability before he joined the defendant's employment. End of quotation. This diagnosis. The claimant did not feel that what glaucoma is in medicine. Neither did the defendant show any medical evidence that glaucoma is hereditary. In the circumstance, the court cannot speculate on whether claimant had glaucoma and if it is hereditary. What is before the court is a prescription of eye drops as a C6, C5. Claimant had made demand for 9,000 in Exhibit C3. Defendant in his different action therefore could not continue to bear responsibility firm that NSITF never got back to them. Upon examination of the said letter to NSITF Exhibit GW1D, it was written on the 10th of June 2022, that is 42 days after the defendant was notified of the accident. It was, however, received on the 20th day of June, going by the acknowledging stamp of NSITF. By the provisions of the ECA, an employer has 7 days to report a workplace injury to the NSITF after being notified of the injury, while the employee must notify the employer within 14 days of the injury. Failure to report within the time frame is an offense and may lead to penalties. As for the NSITF form, Exhibit GW1E, the court noted that the form was completed by the defendant. There is no acknowledgement from NSITF that it was received and receiving necessary attention. More importantly, defendant did not show evidence that he is a contributor to the fund, which is what will, in the first place, make her injured workers eligible to draw from the fund. Defendant has said in paragraph 4, sub 5 of his statement of defense and paragraph 23 of the GW1's witness statement on oath that the effect of the slash would have been immediate damage and blindness. There is, however, no evidence by way of a medical report. Neither was there an expert witness fielded during trial to confirm this assertion. This in paragraph 114 to 116 above. This court finds that if the defendant has shown evidence that he is a contributor to the fund and reported the injury timely to NSITF, the treatment of the injury of the claimant would have been taken over by the NSITF. The ECA is a no-fault scheme run by government for workers. The defendant failed in his duty to comply with the ECA. It is therefore my holding that the defendant is liable for general damages. The claimant is a 30-year-old man and has to be on medication for his eyes for a long time to come. This court hereby awards the sum of 5 million naira as general damages. I so find and I hold. This court hereby orders that the defendant is liable in general damages for negligence and in the sum of 5 million naira. only. And
As copy.
same. The second arm of the relief is for aggravated damages. This award can only be granted where and when it was pleaded and proved that the defendant's conduct or act constituting the wrong injury was, in the peculiar circumstances of the case, arbitrary, oppressive. See Garba JCA in Onuchukwu versus Fidelity Bank. Parties are in agreement that upon receipt of the report of the incident on the 29th of May 2022, which was 10 days after the incident, the defendant gave a referral note to the claimant and he visited Ruby Medical Center and was later referred to Metro Eyes Clinic. There was a prescription for eye drops as Exhibit C5 and a demand for payment of 9,000 by the claimant's counsel, Exhibit C3, to which the defendant declined. Defendant in the statement of facts stated that on the 23rd of May 2022. This was affirmed by the claimant during cross-examination. Defendant also claimed to have reported the matter to NSITF in paragraph 6 and 7 of his statement of defense and exhibited data dated 10th June 2022, Exhibit DW1D, and NSITF form Exhibit DW1E. In the circumstance, can a reasonable man adjudge the defendant's conduct as arbitrary, oppressive, outrageous, vindictive, and high-handed? This court does not think so. A claim for special damages in labor relations must meet the twin requirement of proof as to entitlement and how the quantum of the sums claimed was arrived at. In Mr. Suraju Rufai versus BPE, unrepeated suit number NICH/LA/18/2023-2013, the judgment delivered on the 4th of June 2018, and Mr. Mohammed Dongos versus ENL Consortium Limited. Citations all provided. There is little or no attempt by the claimant to meet these three requirements in both his pleadings and depositions. These particulars of the claimant is not convincing proof for a claim for special damages except if corroborated by some other credible evidence. Claimant's relief, being monetary in nature, should be specifically pleaded and strictly proved. In other words, items constituting a claim must be particularized in the pleading and proved by cogent evidence for ease of ascertainment, qualification, and calculation of the sum claimed. See Ozigbo versus Ozigbo Engineering Limited versus Uamadi. Citations are all provided. See also UTC Nwokoroku, UTC versus Nwokoroku. Citations all provided. It was where it was held, and I quote, "It is the law that special damages must be strictly proved, but the term strict proof of special damages really requires no more than the evidence must show the same particularity as is necessary for its pleading." End of quotation. For special damages to be awarded, apart from being specifically pleaded, there must be in respect of claimable heads of damage, and the special damages should easily lend themselves to quantification or assessment and supported by credible evidence. See Vital Investment Limited versus CAP PLC and O1 Overseas Agencies versus Brownwen Energy. Citations all provided. In Onyo-Owora versus Onyo-Owora, citation provided, the Supreme Court warned, and I quote, "On no account can a trial judge make his own assessment or speculate on special damages. An assessment would be correct and valid if it was arrived at strictly on the evidence accepted by him as establishing the amount to be awarded." In the instant case, under the particulars of special damages, the first is purchase of Gulf Nepafenac tablets at 3,000 naira for 2 weeks, which is 78,000 naira. What the claimant tendered as Exhibit C5 is the prescription, not the receipt of purchase. The second is mobilization to Abeokuta Eye Clinic at 5,000 naira monthly, totaling 55,000 naira. There is no invoice to indicate the expected amount for transportation to Abeokuta. Neither is there a receipt from a bus service or evidence of fuel receipts to convince this court how that amount was arrived at. The third is loss of income as a result of bad eyesight at 70,000 naira monthly. totaling 840,000 naira. This court had earlier found that the claimant of his own volition decided not to tender his employment letter. There is no evidence before this court as to the monthly earnings of the claimant. This third particular is therefore unknown to the court. The fourth is the cost of litigation at 750,000 naira. There is no receipt that the deposit on account or payment in full was made. The claimant decided to lump together claims for the same period. The law is settled that special damages must be specifically pleaded and strictly proved with concrete evidence, such as receipts, invoices, or authenticated documents to substantiate the exact loss claimed. The claimant bears the burden of proving these specific pecuniary losses with precision. In the absence of sufficient proof and particularization of the claimant's entitlement to the relief sought as per relief 6, this court is unable to grant him. Accordingly, this relief of the claimant, this leg of the claimant's fails. This relief sought by the claimant fails for want of evidence, and it is hereby dismissed. I so find and I so hold. All sums hereby awarded in this judgment shall be within 30 days from the date of this judgment, failing with simple interest of 10% per annum shall apply. I make no order as to cost. Judgment is entered accordingly.
As the court pleases. We are most grateful, my lord.
As the court pleases. My lord, we are most grateful for the well-considered judgments. May God continue to bless the court with more wisdom.
My lord, we are equally grateful for the judgment.